Hello everyone, welcome to our webinar on shaping UK trade to support climate goals. This webinar is brought to you by the Institution of Environmental Sciences. Today's webinar will be presented by Ruth Bergan, coordinator of the Trade Justice Movement. This is a national network that campaigns for socially and environmentally sustainable global trade. Ruth joined the Green Party in 2007 and has stood for election in local, national and European elections. Today, Ruth will be discussing how international trade agreements impact on governments' ability to meet their climate change commitments.
Hi everyone, thanks very much for joining the webinar, and thanks to IES for the opportunity to do this today. I know many of you are experts in the field of climate and environment, so I just want to be really clear that my expertise is in the world of trade, and that's where the focus of my talk will be today. I'd be really interested in hearing towards the end of the talk any thoughts about how this relates to work that you're doing. So what I want to do today is give a brief outline of the trade policy landscape, just to situate the discussion and to sort of help those of you for whom trade policy is relatively unfamiliar. I'll talk about some of the major institutions and the agreements that are already in place or in negotiation in terms of trade. And then I'm going to dig a bit deeper into two of the most important deals for climate goals. So the World Trade Organization and the Energy Charter Treaty, and look at how they relate to climate goals. Then I'm going to briefly look at what the UK could do differently in the post-Brexit world in which we live. And I'll talk briefly about the kind of opportunities and challenges that presents to us. So moving on fairly swiftly, just an overview of what the trade policy, the international trade policy landscape looks like, and just a little bit of history, which I think kind of really sets the scene for how trade is changing and how it relates to climate goals. Starting in around 1948, trade agreements, and in particular what was called the General Agreement on Trade and Tariffs, were deals that looked really only at goods. So you had lots of deals that said, well, if you lower your tariffs for my export of wool, I'll lower my tariffs for your exports of steel. And so the deals looked really exclusively at goods and at border taxes on those goods to try and facilitate increased trade. This was more or less the case until around the mid-1990s, when a number of new agreements were signed and brought together under the World Trade Organization. And this really cemented an approach to trade policy and trade rules, which saw them expanded to apply to a whole raft of issues, such as trade in services, property rules, so that's patents and things like that, some international investment measures, and so on. So this really expanded the scope of what trade policy covered and the kinds of areas that it has an impact on. Under the WTO, there are still limits on that, so the investment provisions are quite limited, and I'll come back to kind of what happened in response to that. Negotiations at the WTO continue with a view to expanding even further the scope of trade policy, but since 2001, those negotiations have stalled due to difficulties in what they call the Doha round of negotiations. This was a round that was meant to benefit developing countries, but it's been really controversial both with countries north and south, and there's been relatively little movement recently. And last year at the ministerial conference, richer countries basically withdrew their support for the round. So the WTO has become quite problematic in terms of negotiations, and one of the reasons for that is that our own Leon Britton, amongst others, insisted that there had to be consensus, so that there had to be an agreement amongst all 162 countries before agreement could be found. So in terms of negotiations and developing new rules, the WTO has been somewhat ineffective in recent years. Where it is very active is in dispute settlement between countries. So if there's a trade dispute between countries, they take it to the WTO dispute settlement mechanism. And I'll come back to this later because it relates quite closely to climate goals. So partly because of the stalemate at the WTO, but also to try and push forward on issues that were not being covered by the WTO anyway, countries have moved to negotiate deals either bilaterally, so between two countries, or plurilaterally, so that's between groups of countries. Probably the most well-known recent deal is the Transatlantic Trade and Investment Partnership, that's TTIP, which you may have heard of. I'm not going to specifically talk about TTIP today because there's quite a lot of uncertainty about it. In terms of Brexit, there's a good chance the UK is no longer in the deal. There are elections in France, Germany, and the Netherlands that might affect whether or not it goes ahead. And Donald Trump has also said he's not very keen on the deal. So actually the status of that deal is quite kind of uncertain. But TTIP is one of a number of what we call mega regional deals. There's also the Trade in Services Agreement, which has some kind of links to climate issues. There was the Transatlantic Trade Partnership, Trans-Pacific Partnership Agreement, but Trump has pulled the US out of that, and again, lots of uncertainty about whether that will go ahead. The EU also has a large number of trade deals, particularly with countries like South Korea. It's been negotiating with India for a long time, so you get a picture of just how many of these deals are coming up. And today there are thousands of those deals in existence. Some are very comprehensive. Some only look, for example, at investment flows between countries. And one of the biggest growth areas for trade policy is in investment. So in how countries treat investment coming from a different country into their country. And so the rights that those investors and the protections that those investors get. And what's really noticeable is that there's been a really big spike in the number of disputes that have been brought under those cases. So in the mid-90s, we saw a handful of cases, 3, 4, 5. At the end of last year, there were 750 cases against countries. And I'll talk more about how that works and the kind of difficulties with that. And the Energy Charter Treaty is an example of one of those deals that really focuses on investment. So what does all of this have to do with climate and the environment? Well, one of the most important ways, and the kind of issue that I want to focus on now, is the way that trade policy interacts with energy provision and energy policy. We know that the phasing out of fossil fuels is the most important step we need to take to address climate goals. So I'm going to focus on how trade facilitates or otherwise that phase out. So as I've said, I'm going to start with the WTO and just talk about how it relates to climate goals, and just give you a little bit more detail on how it works. So as I've said, it was established in '94 and works through negotiating rounds, and under its auspices there are already a number of deals in existence. One thing you should know about people who work on trade is they become very, very familiar with a large list of acronyms. I won't go into all of them, but those acronyms you can see there are some of the deals that exist. There are currently no energy-specific provisions within the WTO agreement, so there isn't a WTO agreement on energy or investment in fossil fuels, for example, but the provisions of the WTO generally also apply to trade and energy goods and services in the same way that they apply to all the other sectors. So one of the most significant provisions under the WTO is that governments are prevented from setting standards that are more trade restrictive than necessary to fulfill a legitimate objective, or that have the effect of creating unnecessary obstacles to international trade. So you can see that those restrictions are quite significant, and these are sort of principles that underpin all of the agreements within the WTO. And it creates a significant burden of proof for government. So they have to prove that their objectives were legitimate. And obviously that's quite vague legally and is left really to interpretation within the WTO dispute settlement. And this kind of creates really kind of strong limits on the kind of policies that they can introduce. And again, having the effect of creating unnecessary obstacles, again, quite a kind of vague way of talking about the kinds of policies that you're allowed to introduce. And the bar is set really high for exemption. So, for example, if you want to offer government support to the renewable sector, the bar for saying that your support to that sector is not trade restrictive internationally and doesn't create obstacles, unnecessary obstacles to international trade, is set quite high. And we'll see that a number of countries have faced cases under the WTO against policies that they've put in place to support renewables sectors. And what's interesting is that through the WTO, a lot of renewable projects have been challenged already, but fossil fuel measures and subsidies tend to be left untouched. One of the reasons is that there's no exemption, no explicit exemption for environmental subsidies under the WTO. The other is, of course, political, in that countries are reluctant to take cases against each other where it has to do with kind of critical energy services or goods that they need. So if you fear that Russia's going to cut off your gas if you take on their gas subsidy program, you're highly unlikely to take them to the World Trade Organization to challenge them. The other problem with the WTO is the way that it defines a subsidy. So subsidies have to either be explicitly linked to increased exports or to the use of domestic products. So your subsidy would have to say, in order to receive this subsidy, you have to also invest some of your R&D into the local economy, for example. And fossil fuel subsidies often don't do this, so they often are exempt from the WTO rules because of the way that WTO rules are designed. And move on to the next slide. So you'll see at the bottom, there's a quote there from Pascal Lamy, who was the Director General of the WTO until 2013-14. And he said that the discussion on the reform of fossil fuel subsidies has largely bypassed the WTO, which was a reflection of his frustrations in an inability of the WTO to really tackle this issue. In contrast to the position in terms of fossil fuels, countries are increasingly being challenged in terms of their renewable energy programs. So in Canada, India, the US, China, Italy, and Greece, they've all been brought to the WTO dispute settlement mechanism, and India and Canada have already been found in breach of their obligations. And what that means in terms of the WTO is that another country is allowed to impose trade restrictions, trade retaliation on you. So whereas maybe they were buying Greek goods, I don't know, Greek raki perhaps, and it was at set at a certain tariff level, in response to the finding on renewables, they could increase those tariffs, making it harder for Greek producers to export. And a lot of these challenges relate to feed-in tariffs and to the design of feed-in tariff programs. A lot of feed-in tariff programs require investors to invest locally, what are called local content requirements. And a lot of governments need to have those as part of their measures because it allows them to justify what are often quite high costs to the state in terms of investment in infrastructure and so on to facilitate the programs. So politically, for a lot of countries, local content requirements are necessary. And what we saw in the Canada case was that Ontario, who'd been using feed-in tariffs and using local content requirements, had to cancel the program, and a number of renewable energy schemes were halted. And you'll see there that the Centre for Global Development conclude that China and other countries are today being straitjacketed by the subsidies are bad ideology. The global battle against climate change is being fought with a depleted arsenal. So that's really a kind of plea to allow these kind of subsidies to continue. So that's an overview of how the WTO relates to fossil fuel and energy. I'll move on quickly now to look at the Energy Charter Treaty and just give you an overview of kind of what that might mean for climate goals. So the Energy Charter Treaty is a plurilateral investment treaty. It's with 54 member countries, although it doesn't include all oil producers. So some big ones are excluded at the moment or are not members, such as the US and Saudi Arabia. And its main aim is to protect, promote and liberalise investment in the energy sector. And the energy sector is the single largest destination for foreign direct investment. It takes up about 1/5 of the global total of investment flows between countries. So it's a really significant sector, and that makes this a really kind of important treaty when you're looking at how you might reshape the energy sector to meet climate goals. So the treaty has 4 main functions. Sorry, stay on that page for now. So yeah, which I've been through. Sorry, I'm getting a bit lost. Some of the main issues that we see with the treaty are as follows. So there are several thousand investment treaties globally, and most of them have in common a very broad definition of investment. So that means investment could be property rights, shares, intellectual property. So you could be no more engaged in the local economy than holding shares in a particular company, and you then have the right to access the protections that the Energy Charter Treaty offers. As well as very broad definitions of both investment and investor, you have a very strong ability to enforce the rights that are set out under the treaty. So this is something called investor to state dispute settlement, ISDS, which you may have heard of. This is the clause that allows companies to sue governments if they feel that a policy or its implementation has harmed their investments. The average cost of a case of this kind is $8 million. That's just the cost of the legal costs, and the awards run to millions, sometimes billions of dollars. Interestingly, in an energy case, although a slightly odd energy case, Yukos Universal sued Russia and were awarded $50 billion, which is the biggest case we know of so far. And the investment had been made through a tax haven in the Isle of Man. The energy sector and the ECT itself are the largest source of this kind of dispute. So it really is an area where energy companies are very active in trying to shape country policies. Half of all the cases registered at the World Bank relate to oil, mining, gas and other energy issues, and the ECT has been used to bring 89 out of the 750 cases that I mentioned. And it's worth remembering that the rest of the cases, so the other sort of 650 or so cases, are divided between about 2,000 other treaties. So that just gives you a sense of how significant the ECT is in this area. And the rights that are offered to investors, so the things that they're allowed to use as means of challenging governments, are very comprehensive. So, for example, they are protected under the treaty against expropriation. And normally what this means, kind of in sort of traditional understanding, is protection against government forcibly nationalising an operation without compensation. But the definition of expropriation is so broad and has been kind of so broadly interpreted in the tribunals that hear the cases, that it's been used to cover basically any regulatory measure that's deemed to harm, affect or interfere with an investment in a way that has the effect of an expropriation. So you can see that that's really quite a broad definition. And the second really problematic provision is the right to what's called fair and equitable treatment, which sounds fairly anodyne, but again, it's very broadly defined in the treaty, and tribunals have also kind of pushed the boundaries of what that can cover. So, for example, in a case against Mexico, the tribunal found that contracting parties, so that's the government, were required to meet the basic expectations taken into account by an investor when they were making their investment decision. And this meant that they had to act in a consistent manner, free from ambiguity and totally transparently. And I think I've yet to come across a government that could meet that kind of high standard of operation. And the investor was had the right to know beforehand any and all rules and regulations that might govern its investment. Okay, so you can see that the bar is set there really high, and that kind of allows a lot of scope for challenges. And again, as under the World Trade Organization, the ECT bans local content requirements. And by way of a comparison, when you look at the language on sovereignty over energy resources and environmental or climate protection, the ECT is really weak. So protections, so the paragraphs in the environment chapter, which it does have, are non-binding and they are not really enforceable. And it merely says things like the parties will take account of, promote, have regard to, encourage, cooperate in various aspects of environmental policy. So really none of the clout of the investor to state dispute mechanism. So in terms of concrete impacts, we can look to some of the cases to see the kinds of policies that get challenged. So in 2007, a Swedish energy company called Vattenfall was given a water permit to build a coal-fired power plant on the banks of the River Elbe. There was a lot of concern about the environmental impact, and eventually local authorities imposed strict environmental conditions on the contract to limit the water usage. And this kind of reflected EU regulations, for example, to protect fish species. Vattenfall argued under the Energy Charter Treaty that these environmental measures were so strict they made the plant uneconomic and therefore constituted an act of indirect expropriation. The case was settled eventually in 2011. Germany issued a new permit that significantly lowered the environmental standards compared to what had been originally proposed. So you can see that the kind of threat of a case is really significant for countries, even kind of relatively rich countries like Germany. And what I think is really interesting is that there are really no equivalent agreements to protect the climate or environmental goals. Nothing so comprehensive, nothing that has the same level of enforceability, and nothing that offers companies or kind of ordinary people a mechanism to challenge in the same way policies or implementation that might damage or kind of hinder climate goals. And in terms of the limited coverage that the ECT has, so this exclusion of the US and Saudi Arabia, there are moves, there are plans to develop the treaty into a much more comprehensive one that would cover more countries, including the US. It's very interesting to look at who's on the advisory board. It includes basically private investment interests such as E.ON, the China National Petroleum Corporation, Gazprom, Shell, Dow Chemicals, BHP Billiton and BP. The Bulgarian energy holding company sits on the board, and they interestingly were ranked the industrial facility causing the highest damage to health and the environment by the European Environmental Agency a couple of years ago. What's really noticeable is that there's no parallel advisory panel on environmental or climate issues, and there are no members of that advisory panel that come from a kind of purely climate perspective. So that gives you an overview of two of the institutions and agreements that look at the energy sector and the kinds of barriers that they create to achieving some of the climate goals, and that, in particular, the kind of move towards renewables and away from fossil fuels. So I think in theory, there are lots of opportunities in the UK at the moment to address some of these issues. UK trade and investment policy used to be decided through the EU, so the EU had full competence for trade and investment policy. And of course, we were part of the negotiations and part of designing the policy, but it was done as part of the 28 EU member states. The form of Brexit that the government's chosen means that we will get back competence for all of that policy. And that that potentially offers an opportunity because it means we can shape our own policy. We need to redesign trade policy. We need to go back and renegotiate agreements with partner countries. And we could do that to better reflect our commitments on climate change and to ensure that it's kind of fit for 21st century challenges. The reality is perhaps not so sunny. So some of the key players in the UK government are not as supportive of the climate agenda as we might want. And in particular, I think reluctant to sort of bring sort of have trade policy influenced and shaped by the climate agenda. So the key players are kind of Boris Johnson in the Foreign Office, Liam Fox in the Department for International Trade, and David Davis in the Department for Exiting the EU. And if you look a bit at their kind of record on climate, they kind of sit more on the skeptical side of the spectrum. But I do think that there's an opportunity for civil society organisations to keep raising the issue and to keep up the pressure to design trade in a way that is compatible with our climate goals. And there are some concrete things that we could be doing. So ideally, it'd be great to see a real rethink of the trade policy landscape in the UK. And I think one of the reasons for this is kind of to go right back to the beginning of the talk. We've expanded the system from goods to cover services, investment, public procurement, and so on. And really, it can't operate in the same way as a system that was designed to facilitate trade in goods only. And I think it needs more stakeholders to be engaged in the process, as I've mentioned, in terms of the stakeholder panel, for example, on the ECT, and there need to be more checks and balances so that trade doesn't clash with climate and environmental goals. Since we're such a long way from that kind of a rethink, there are some fairly easy ways that we could reshape existing deals. So, for example, some really robust carve-outs so that government policies to support climate goals aren't challengeable, and that's legally much better protected than it currently is, so that countries don't fear a backlash if they support renewable energy or take other climate or environmentally friendly measures. And those kinds of carve-outs already exist in trade policies, but for tax, for example, rather than for things like climate. So it would be possible, and it wouldn't be kind of completely new way of thinking. I think that existing bilateral investment treaties really need to go. The kind of vague wording, the broad interpretation, I think makes them very dangerous in the way that they can be applied. They're far too biased in favour of investors, and in practice operate as a kind of insurance mechanism for them, whereby we the people pay for their business risk. And I think that's just not a kind of sustainable way of designing investment agreements. And indeed, I think they undermine the polluter pays principle, because in effect, governments are asked to pay compensation for measures to support climate goals. So I think we need to completely rethink at least that aspect of the trade deal. And I think there are existing alternatives out there. Countries like India, Malaysia, South Africa have already started thinking about alternatives. And indeed, companies can use things like political risk insurance as alternatives to recourse to agreements. And I think finally, what the UK could start doing is looking for a much better balance between trade and climate deals. And this comes back to my point that trade deals are binding and highly enforceable. Often climate deals are not, and I think we need to get the balance right, the balance between those two things better, and to offer greater enforceability to climate deals and maybe less enforceability to trade deals. And I think that's really a message of not looking at those. At the moment, most trade and climate agreements are looked at in isolation. Indeed, the EU insisted that they were last year at the climate talks. And I think we need to move on from that and find other ways of and find ways of bringing the two together so that they are compatible. So that's yeah, a quick overview of where I see the issues in trade and climate. If you're interested in finding out more, we have a report on our website, which you can see now. And please do follow us on Twitter or get in touch if you've got other questions. Thanks.
Thanks, Ruth, for that really interesting webinar. So we have a couple of questions from Richard Tams. One of these is there a list of Energy Charter Treaty members available?
Yes, there is a list. It has a website and you can go and have a look on it. I can't give you it now, obviously it's 54 member states. Companies are not individual members of it, but membership by the state offers the companies the kinds of protections that I was talking about.
And the second question from Richard Tams was, is the Energy Charter Treaty a legal document in itself? Is it enforceable under law?
I'm not entirely sure I've understood that question, but yeah, it's a legal document. It's a binding treaty. So once you're a signatory, you have to comply with its provisions. And that's you as a government have to comply with its provisions. And if you don't, in the case of the Energy Charter Treaty, I think you only have investor to state dispute settlement. But for example, under the WTO, you have state to state dispute settlement. So where the states can use WTO mechanisms to challenge each other, and that's a sort of legal process which gives the winner the kind of certain options in terms of trade retaliation. So the things that I was talking about in terms of raising tariffs one example was Brazil challenged the US on, I think it was their tuna. Their legislation in terms of kind of tuna fishing. Actually, no, it wasn't. It was cotton. So Brazil challenged US cotton subsidies, saying that they were unfair and trade distorting. Brazil won, but because the US is relatively rich and able to do this, they now basically pay a subsidy to Brazil to be allowed to maintain their own subsidy. So they're sort of subsidizing both Brazil and themselves. So it's legally enforceable. And in the case of WTO, it sometimes works in slightly strange ways. In the case of the ECT, it can lead to financial compensation for a company.
And we have a question from Adam Donnan. So with the USA and maybe Britain seemingly favouring bilateral deals rather than multilateral agreements, is this new paradigm likely to be beneficial to the environment?
So Donald Trump seems to not want the existing deals that we have. So the Trans-Pacific Partnership Agreement was probably the furthest along. But he has been saying that he wants to go for bilateral deals, and he's mentioned one with the UK. I have absolutely no confidence that a deal shaped by Donald Trump and his administration would be any better for the climate or the environment, given their position on both of those issues. We know he recently lifted so Obama had blocked the Keystone XL pipeline. Trump has kind of reinstated that, and that's going ahead. As an interesting aside, TransCanada were using a free trade agreement to sue the US for having blocked the pipeline. We thought that having the pipeline reinstated would mean that that case would drop. It seems they're going to continue with it because they feel that the delay has negatively impacted on their investment. So it gives you a sense of just how much these deals are used. I think the UK is going to be in a weak position in terms of trade deals. It's been fairly clear communicating that it needs those deals, trying to put a positive spin on it as kind of the UK being a global actor. But in effect, I think the US is highly likely to come along and say, here's the trade deal we want, sign on the dotted line. And I can't see the UK having a huge amount of influence. As I said before, I don't have a lot of influence either in the UK's commitment to climate or to the likelihood of it shaping its trade deals to be compatible with climate deals. I think actually the multilateral institutions are slightly more likely to lead to better outcomes, if only because you have such a large number of countries involved. The power of the bigger countries like China and the US is sort of diluted somewhat, and countries often group together to argue for particular positions. The fact that it's stalled kind of takes that sort of potential away somewhat. But I think if it could be restarted, that would be the best. It would be better than bilateral deals, and in a kind of ideal world, I think we would be fundamentally rethinking our trade institutions and trade agreements.
Well, thank you, Ruth. There is one more question. So does the Paris Agreement give any legal mechanisms to resist some of the legal challenges to national governments that might arise from some of these other treaties and agreements?
So I'm not an expert on the climate agreement, but I did read it. And as someone who spends a lot of time looking at trade agreements, I was a bit confused as to in what way this was actually an agreement. I know lots of people welcomed it, and it was a historic agreement. For me, it wasn't even an agreement. There were no binding provisions in it. Countries seemed to commit to, at some point, providing an action plan, as yet undefined, and there would be no repercussions if they didn't. So, frankly, no, I don't think it does. Certainly, I can't see it challenging any of the provisions of the ECT, because from what I saw, there's nothing in it to discipline countries that don't meet their commitments which are already very weak and vague. So I'm not very optimistic about the climate agreement either, I'm afraid.
I actually just have a question. So regarding your last slide on the UK, is there anything that the UK public can do to kind of make their opinions heard on the issue on the balance between trade and climate?
So I think it's an interesting position, because MPs at the moment are not kind of not very up to speed with trade policy, and I think they're really open to people going to talk to them about their concerns. So we have lots of resources on our website. There are lots of other organisations that work on this. So the International Institute for the Environment and Development have lots of really good reports. So if you wanted to kind of gem up on it and then go and talk to your MP, I think the door would be open. And I think really talking to them about making sure that the UK's new trade policy is compatible with its climate commitments would be one step. A number of organisations, so the Trade Justice Movement is a network of about 70 organisations, and a number of those work on these issues. So Friends of the Earth, for example, but also organisations like Global Justice Now, Friends of the Earth and CAFOD also have work either starting or ongoing on these kinds of issues, and you can certainly kind of join in with their campaigns. There will be a trade bill coming up in the next year or two, and that'll be, so this is where the government sets out what its approach to trade will be. I think that'll be a really big opportunity to say quite loudly that this needs to be sort of compatible with the climate, and that kind of period, that lead into the development of the bill will also be really key to trying to influence and change it. I was sort of unoptimistic about some of the ministers involved. One minister who I think does kind of see the opportunities of bringing trade and climate together is Greg Clark, who's at BEIS. So I think that's a business environment, innovation and skills. And he has been saying some positive things about how the UK could become a kind of leader in climate technology. And so I think possibly sort of following him, if organisationally there are ways for you to talk to him and kind of support him to talk to his colleagues and persuade his colleagues that there are benefits to shaping trade policy to support climate policy, then that also would be positive.
I think that is everything. Thank you everyone for listening. Thank you all for joining us today, and I hope you enjoyed the webinar.